Welcome back, everyone. We really hope you enjoyed the first session of our seminar, and let's get started with our next session. Our next speaker is Jane Kotzmann, Associate Professor at Deakin Law School. Jane will be speaking today about the legal status of animals and how changing public views present an opportunity for legal reform. Over to Jane.
Hi, my name is Dr. Jane Kotzmann, and I'm an Associate Professor at the School of Law at Deakin University. Thank you to the organisers for asking me to present at this conference. I want to begin by acknowledging, in the spirit of reconciliation, the traditional custodians of country throughout Australia and their connections to land, sea and community. I pay our respects to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today. Today, I am presenting on whether the legal recognition of animal sentience is reflective of changing animal ethics. So I'll divide this presentation up into 4 broad questions, and you can see them on the screen. Firstly, what is animal sentience and why does it matter? Secondly, how does the law recognise animal sentience? Thirdly, is the growing trend towards legal recognition of animal sentience reflective of changing animal ethics? And finally, is sentience recognition sufficient to reflect the changes in public animal ethics? So we begin with this first question. What is animal sentience and why does it matter? So we're starting with the basics here, and that's because many people may be unfamiliar with the term sentience and unsure as to what it means, or perhaps you've come across it before, but its concrete meaning is perhaps a little blurry. At first, it might seem like this question is easy to answer. Sentience refers to an individual's capacity to subjectively experience the world around themselves. However, when we look to the scientific literature, there are multiple definitions of sentience and they're not always in alignment. They vary. So we might have definitions as those shown on the slide. For example, Jonathan Birch and his colleagues in their review of the evidence of sentience in cephalopod mollusks and decapod crustaceans referred to sentience as the capacity to have feelings. David Mellor refers to sentience as being conscious, whilst Donald Broom refers to sentience as having a range of abilities. There are, as I've highlighted here, multiple definitions of sentience, but in broad terms, they, I guess, generally refer to an ability to subjectively experience life, so that subjectively component is important, including the capacity to have both positive emotions like joy and happiness or contentedness, as well as negative emotions like pain, suffering, or anxiety. It's possibly the second component of this overarching question that's actually more important. Not just what is animal sentience, but why does it matter? Why are we talking about it? And in this respect, the reason that we talk about sentience and have been talking about sentience increasingly in recent years and decades is that sentience provides a strong moral reason, and some would argue even potentially the only moral reason for caring really about humans and animals and their protection. It is generally considered morally wrong to cause other humans pain and suffering, and that's because they are sentient. They can feel pain, they can suffer. Similarly, the basis for not causing harm and suffering to animals can also be considered to be their sentience. So that's the answer to our first overarching question, what is sentience and why does it matter? We shift now to our second question of how does the law recognise animal sentience? And you can see from this slide that I will divide up this discussion into, again, 4 components. Firstly, the implicit recognition of sentience in the law. Secondly, the ways in which the law has, particularly in recent times, expressly recognised animal sentience. Thirdly, the particular meanings that come about as a result of incorporating sentience into the law. And fourthly, recognition of sentience in the Australian context. So beginning here with our implicit recognition of animal sentience, it might come as a surprise to many people that much of our existing animal welfare legislation actually doesn't state why it's important to protect animals from harm and suffering. The types of laws that I'm talking about, animal welfare laws, animal care and protection laws, prevention of cruelty to animal laws, so various titles, but in broad terms, the same types of laws, have a long history dating back in the United States to the Puritans of Massachusetts Bay Colony Code of 1641, and the United Kingdom, from which our laws directly derive, in the form of the Cruel Treatment of Cattle Act of 1822. Today, these types of laws are enacted in most jurisdictions in developed countries, and that includes all Australian states and territories. While much of this legislation doesn't actually expressly say why it's important to protect animals, we can come to a conclusion that there's an inference to be made that the legislation recognises that animals are sentient, and that's the reason why we go about protecting them. This interpretation can be supported by the ways in which those types of laws criminalise human cruelty to animals and, in some instances, also impose obligations on humans to care for animals in particular ways. So it could be argued that if animals weren't sentient, those kinds of laws wouldn't exist. To look at some examples we have in the right-hand box here, in Victoria, the Prevention of Cruelty to Animals Act of 1986 states that an act of cruelty towards an animal includes acts or omissions with the result that unreasonable pain or suffering is caused or likely to be caused to an animal. Similarly, the Prevention of Cruelty to Animals Act of 1979 states that an act of cruelty towards an animal includes acts or omissions that unreasonably, unnecessarily, or unjustifiably cause the animal to experience pain. And these acts can include beating, kicking, killing, and wounding an animal. So these kinds of references to animals' feelings or the capacity to have feelings, particularly in this type of legislation to pain and suffering, can suggest that prohibitions on cruelty to animals are underpinned by a recognition that animals are sentient. We can see this argument expressed quite succinctly by Laura Dunn and David B. Rosengard in their article entitled "A Dog is Not a Stereo, the Role of Animal Sentience in Determining the Scope of Owner Privacy Interests under Oregon Law," published in 2017. They state, "Without being sentient, animals cannot suffer. Sentience is therefore implicitly at the root of animal protection laws." So that's the summary of the argument that these kinds of laws, even though they don't expressly, or they may not expressly recognise animal sentience, still do so implicitly. Nevertheless, it's important to keep in mind that recognition of animal sentience, or the understanding of animals as being sentient, doesn't provide a full accounting for animal welfare legislation. And this is because the laws that we're talking about can be seen to operate for other types of purposes. For example, they might be argued to be in place to protect human property interests. They might be argued to be in place to actually protect humans from cruelty because of the link that's been identified between cruelty to animals and cruelty to other humans. That these kinds of laws operate for other purposes other than protection of animals from pain and suffering is supported by the reality that the protection that is almost invariably provided in these types of laws is not offered to animals based on their understood level of sentience. Rather, animals are protected on the basis of what they're being used by humans for and the contexts in which that use occurs. So even if we conclude that animal sentience is implicitly recognised by animal protection legislation, that legislation and that rationale and reasoning can't be used to provide a full accounting for such legislation. So we've identified that animal welfare legislation can be considered to implicitly recognise that animals are sentient. Perhaps more promising for animal advocates is that laws in recent times have shifted towards expressly recognising animals as sentients. This can be considered somewhat of a worldwide trend. In recent years and recent decades, many countries and jurisdictions have changed laws, amended their laws to recognise that animals are sentient. European Union was actually the first jurisdiction to recognise animals as sentient beings, and that was via the Treaty of Amsterdam in 1997. Today, Article 13 in the Treaty on the Functioning of the European Union of 2016 also recognises animal sentience. So this replaces the Treaty of Amsterdam and provides, as you can see, in formulating and implementing the Union's agriculture, fisheries, transport, etc. policies, the Union and the Member States shall, since animals are sentient beings, pay full regard to the welfare requirements of animals. So we can see not only does the provision recognise that animals are sentient, but it also imposes a positive obligation on states that are members of the EU to pay regard to animal welfare when they are developing and implementing policies in particular areas. In perhaps slightly different terms, but similarly in terms of express recognition of animals as sentient in law, multiple other jurisdictions have also changed their laws in this respect. This is certainly not an exhaustive list of jurisdictions that have done so. However, the Netherlands, in their Animals Act of 2011, recognise animals as being sentient. France, in its Code Rural et de la Pêche Maritime and their civil code, as well as Lithuania, in their law on the welfare and protection of animals, all recognise animals as being sentient beings. Non-European jurisdictions as well have embraced this kind of shift in legislation. Chile has recognised animal sentience since 2009. Peru and Colombia recognised it in 2016. Similarly, in New Zealand, their Animal Welfare Act of 1999 was amended in 2015 to recognise animal sentience. And Quebec recognised it in the same year, with the UK the most recent on my list of recognitions in 2023. But as I stated, that's not an exhaustive list of jurisdictions that have expressly recognised that animals are sentient. As a bit of a side note here, I just want to identify that we talked earlier about the definition of sentience and how there's various definitions in the scientific literature, and we arrived at a broad definition of what sentience might mean. It's worthwhile keeping in mind that when we put the term into law, it actually takes on its own legal meaning. And what that means for us is that reference to sentience in different laws can have different meanings. So I've got an example on the slide for you. In terms of New Zealand, the Animal Welfare Act in its long title states that one of the purposes of the law is to recognise that animals are sentient. And they don't provide a definition of sentience in the legislation at all. So what they've done is actually leave it for courts to interpret the meaning of that term, and courts have done that. And if you're interested in the case law around that, please feel free to get in touch. In Oregon, in the United States, the offences against general welfare and animals, you can see reference to a declaration that animals are sentient beings capable of experiencing pain, stress, and fear. And from this definition, we see an embracing of the negative feelings or states that might be experienced by sentient beings, but no reference to positive states. And we see, therefore, a limitation in the definition provided there. In the Australian Capital Territory, in the Animal Welfare Act of 1992, the objects of the Act include that animals are sentient beings that are able to subjectively feel and perceive the world around them. And so we see that that's a broader definition, or at least a more comprehensive definition than that in the Oregon legislation, and actually provides a definition in contrast to the New Zealand legislation. So looking at the Australian context, and we'll be quite brief here, I've already mentioned that the Australian Capital Territory recognises sentience in its legislation, and that's as part of the objects of its animal protection legislation. It's worthwhile also noting that Victoria and Western Australia have committed to recognising animal sentience in legislation in the future, and also that whilst the federal or Commonwealth government doesn't legislate directly in relation to animal welfare, it has recognised animal sentience through its entry into the Australia-United Kingdom Free Trade Agreement, which was signed on 17 December 2021. So we move now to our third question. We've established that we've talked about what animal sentience is and the ways in which it's recognised in the law. And here's the crux, I suppose, of the overarching question for the discussion. Is this growing trend, legal trend towards recognition of animal sentience reflective of changing animal ethics? In short, my answer to this is yes, it is, at least partially. I address this question by developing the following 4 points. Firstly, that developments in animal welfare science have contributed to an increasing concern for animals. Secondly, that public awareness of the lived experiences of many animals have contributed to increasing concern for animals. Thirdly, that survey data reveals increasing public concern for animals, as well as changing sentiment around appropriate human-animal interactions. And fourthly, that legislative amendments appear to have been driven, at least in part, by a desire to respond to changing public ethics in relation to animals. So we start here with developments in animal welfare science. In other words, our scientists that specialise in exploration of animal welfare and understanding animal cognition and animal welfare have advanced their knowledge quite considerably, particularly in recent decades. Quite a long time ago, it was in fact the case that some people actually thought animals weren't sentient at all, and not only were they not sentient, but essentially they were kind of akin to machines. This kind of view is attributed most commonly to Descartes and is referred to as the Cartesian understanding of animals, that animals are mere automata. However, in contemporary times, research in relation to animal capabilities is clear that many animals are sentient. And in that respect, many animals are generally understood to have the capacity to feel both physical and psychological pain that is similar to that experienced by humans. So when I say many animals, it's worthwhile noting that this includes vertebrate animals, so animals with backbones. It includes parrots, dogs, pigs, cattle, other farm animals, companion animals, laboratory animals, wild mammals, and birds. It includes amphibians, reptiles, fish, cephalopods, and crustaceans. There is even the suggestion that snails may also be sentient. So we have this increasing understanding of animal sentience. We also have an increasing public awareness of the lived experiences of many animals, and that this public awareness has led to an increasing concern, public concern for the lived experience of animals. This has come about in many ways, but perhaps particularly driven by changes in technology and development of new technologies. So we can refer to various ways in which this kind of message is communicated to the public through, for example, documentaries like Earthlings and Dominion, through current affairs programs like ABC Four Corners. Many of us will have watched the recent expose around gassing of pigs. The Farm Transparency Project repository is one means by which photographic and video evidence of the lived experience of farmed animals is disseminated. And similarly, We Animals is an organisation that advocates for animals via photojournalism. So we have, in sum, this increasing awareness of the way in which animals are living their lives and their experiences, particularly at the hands of human beings. Fourthly, we see through survey data that there is an increasing public concern for animals and that there is a changing sentiment around appropriate human-animal interactions. We have extensive survey data in relation to farmed animals in particular. One particular study in this respect undertaken by Amelia Cornish, David Rabenheimer, and Paul McGreevy actually surveyed the existing literature, so kind of a meta review of literature, looking at concern for the welfare of farmed animals amongst veterinarians, farmers, and members of the public. And they note that the past 2 decades have seen public concern for animal welfare continue to rise, and high levels of public concern for animal welfare across many developed countries. Similarly, we have survey data in relation to New Zealand, particularly in relation to common farming practices such as the use of farrowing crates for gestating pigs. We also have survey data from the United States. I won't bore you by going through all of the various surveys, but in particular, in the Australian context, we have a report reasonably recent now, the Future Eye report, published in 2018, which was actually commissioned by the former Federal Department of Agriculture and Water Resources. And it found that the Australian public's view on how farm animals should be treated has advanced to the point where they expect to see more effective regulation, and that the community believe that animals should have rights and freedoms. Similarly, some research undertaken by Geeta Sham and published in the University of New South Wales Law Journal found that the property status of animals, at least some animals, may not be consistent with contemporary attitudes. So again, in sum, we have very clear survey data indicating that there is a changing sentiment around appropriate human-animal interactions. And finally, in terms of this argument that recognition of sentience is at least partially a response to changing public sentiment, we can look to the documentation that sits around legal amendments, things like explanatory memoranda, second reading speeches and such. And these documents indicate to us that these amendments have been driven, at least in part, by a desire to respond to the changing public ethics in relation to animals. Particularly in this respect, we can look at documentation around the Australian Capital Territories amendments, as well as documentation around the Victorian proposed amendments to the Prevention of Cruelty to Animals Act, which will be retitled once the new legislation comes into place. For example, in the ACT context, the Animal Welfare and Management Strategy of 2017 to 2022 asserts that in the absence of a targeted strategy, animal welfare and management practices are less likely to evolve to meet the changing expectations of the ACT community. So we see this express mention here of expectations and changing expectations. In the Victorian context, the Victorian Animal Welfare Action Plan identifies that community expectations about how animals are treated are increasing. So I turn now to the final question that I want to address in this presentation. We've talked about whether sentience recognition is a response to changing public ethics in relation to animals, and essentially come to the broad conclusion that they are a response. But then my final question is whether sentience recognition is actually sufficient to reflect those changes in public animal ethics. The short answer to this question for me is no. And this is because sentience recognition alone won't bring an end to the ways in which humans use animals, which have actually operated to generate public concern for animals. By way of example, we can talk about farmed animals. So simply recognizing that farmed animals are sentient, that they have this subjective life and experience, for example, pain and suffering, just because we recognize that doesn't mean that we will change any of the practices that might cause pain and suffering to those animals. This is particularly the case in Australia, where welfare protections in legislation, in broad terms, don't extend to farmed animals. And that's because they are instead subject to codes of practice. And those codes of practice are, in general, developed by industry representatives in partnership with government bodies, but government bodies that have or are subject to what might be perceived as a significant conflict of interest, in that they're also responsible for the growth of agriculture. So in broad terms, recognising in law that animals are sentient isn't actually going to change the practices that are legally acceptable. However, recognition of animal sentience could bring further change in the future. So particularly because these kinds of changes are broadly publicised and discussed through media, they may have a further impact on public awareness. And as a result of that kind of escalating impact on public awareness, they might result in further legal change in the future. And hopefully that change is beneficial for animals. That brings me to the end of this presentation. Of course, I welcome questions, and please feel free to get in touch. Thank you.
Okay, Associate Professor Jane Kotzmann now joins us live. Hello and welcome, Jane. And here comes Jane now. Hi, Jane.
Hi, Stan. Thanks for having me.
No, thank you very much for joining us. I'm going to get kick-started with some questions. About the term reasonable or unreasonable actions or omissions in the law, there's increasing evidence that humans rarely use reason when making decisions we act on. I really apologise. That is an old question that has come from a previous presenter. This is part of the glitching that we're having today. I really apologise. Let me see our most recent. Okay, so you mentioned that we're starting to recognise that even snails may be sentient. Why do you think there's such a divide between animals versus insects when it comes to belief and recognition of sentience?
Yeah, that's a really interesting question. I suppose at the outset, the divide might come from the potential impact that would result from identifying animals versus insects as being sentient. Because if we're talking about insects as being sentient, then we have really a lot more to think about in terms about how we actually go about living our daily lives, and what does that mean in terms of, for example, the bees that are in my backyard or the ants I might walk on when I'm going somewhere. So I think that, the potential implications for humans are one of the issues. The other issue, I think, is probably just that there's so much less research that has been done in relation to animal sentience. That said, research in relation to animal sentience, not insects, is very much in its infancy. So when we're talking about insect sentience, that is way beyond infancy. There is, however, some evidence starting to come out to suggest that some insects, at least, are also sentient.
Yeah. Thank you. Why do you think Australia is lagging behind in the legal change to include sentience?
I mean, again, I'm hypothesizing, but my guess would be that Australia has a very strong agricultural economy, and our industry representatives have very strong influence over members of parliament, and it's quite clear from the survey data in relation to consultations around sentience recognition that at least the agricultural industry does not want to have sentience recognised in legislation. So even though the public broadly are in favour of it, industry is against it, and I would suspect that that's probably having an impact.
Yeah, thank you. I can tell you that it's not from lack of trying from groups like the RSPCA advocating for sentience to be in every piece of animal welfare legislation across the country. So, yeah, it is definitely a frustrating one. Next question comes from Ian. In jurisdictions that have recognised animal sentience, what measurable legal or ethical shifts, if any, do you consider have occurred, given that there has been no corresponding evolution of laws of duty of care?
Yeah, another great question. So I guess it depends on how we define measurable legal or ethical shifts. I actually did some research on this, published a few years back, and I looked at jurisdictions including New Zealand, Quebec, and from memory, the EU, I think, as well, as to what's actually occurred in those jurisdictions following recognition of animal sentience. I should preface the comments with, we really haven't had enough time to figure out, I guess, a full picture of what consequences might be. However, in legal terms, the most obvious consequence is that, particularly when you put recognition of sentience in the objects of legislation, the impact that has is on the statutory interpretation of provisions in the Act. So if you have a provision in the Act, the particular piece of legislation that is in some way unclear, then what courts will do is they'll reference back to the objects of the Act to determine what the legislature might have meant when they had that unclear term in the Act. There's a few cases in relation to that. I think some of them were referenced in the chat. A couple from New Zealand. I think in the chat they referenced just one case, but there's also the case of, so there's Ericsson and Ministry for Primary Industries. I can pass on information if anyone's particularly interested. McCartney and Canterbury Society for the Prevention of Cruelty to Animals, Police and Woodhera, Wallace and Royal Society, and there's some as well from Quebec and the EU. But essentially, it's probably a minor impact, but it can impact things like how long can an animal be kept in a carriage for when it's being transported, for example. More importantly, I think sentience, and perhaps Suzanne would agree with me here, provides a really important and strong tool to advocate for increased protection for animals. It's in the legislation. We've all agreed that animals are sentient, and this is at least one of the reasons why we have protective legislation. Therefore, you need to act in ways that actually reflect that understanding and respect for sentience. And I suppose related to that, we have an increased public awareness that animals are sentient, because as I said in the presentation, there isn't really a whole lot of awareness about what the term sentience means, and it gets thrown around quite a bit now. And I think throwing it around in that way actually is building that awareness of what we're talking about when we talk about sentience and why that's important. And thus, hopefully, and I think in some instances, culminating in further change, legislative change for animals, and practical change as well.
Yeah, fantastic. I think a nice segue to another question that we have here, and we certainly hear this on occasion, that the argument that recognising sentience is a slippery slope which will lead to animal rights principles being embedded into law. Have you got any thoughts on that?
I mean, if you've read well, actually, I have research forthcoming in April that actually explains exactly how recognising sentience might provide a legal pathway to animal rights recognition. So I have to admit at the outset, I'm biased in relation to your question, because I think that would be a good thing. Nevertheless, could it be a slippery slope? I don't think so. I mean, it changes very little in terms of actual practice in relation to animals. As I said, it might have an impact, a kind of minor impact on statutory interpretation, but it doesn't change which animals are covered by the legislation and the basic standards by which they must be treated. So if the society is not willing to go to that point, then it won't happen.
Yeah, it's an interesting one. Look forward to reading that research, and maybe it will make its way into our science update for that we share with people as well. So that'll be really interesting. Another question from Dawn, and she suggests that Australia has poor enforcement in relation to farmed animals, regardless of the standard of the legislative content. How do you think we can fix that side of things?
Yeah, excellent comment, and I completely agree with the assertion that we have poor enforcement in relation to farmed animals. I would say more broadly, not just in relation to farmed animals, but in relation to animal welfare broadly in Australia, there is poor enforcement, and that is by and large, I would argue, the result of two things. Firstly, in most states and territories, the RSPCA undertakes the bulk of the enforcement work, and the RSPCA does receive some government funding for that work, but very much insufficient funding. Secondly, I'm just going, sorry, I had a second point, now it's gone, poof.
I can definitely support.
Farmed animals, sorry, yeah, farmed animals. In relation to farmed animals specifically, frequently it's the case it's actually not the RSPCA who is charged with inspecting those animals, it's the state government departments who have a conflict of interest, I would argue, in relation to that work, in that they are also charged with growing the agricultural industry. And then kind of to consolidate those points, we also have a situation where there's very much a lack of accountability and transparency in relation to those animals because there's no other oversight in relation to them. People can't just go and check what's going on. It's really just the department.
Yeah, absolutely barriers to that regulation, unfortunately. Question here about what do you think the minimum biological basis for animal sentience is that could or should be recognised in Australian law?
That's incredibly difficult for me to answer, largely because I'm not a scientist. So my work proceeds from the basis of the scientific research that I read and try and pull together. What I gather from that research is that it's very, very unclear which animals are and aren't sentient. The other thing I'd say in relation to it is, and I think there was another question in relation to this on the chat, around levels of sentience. Mm-hmm. Sometimes people talk about levels of sentience, but as I understand it from the scientists, it's actually a very dangerous thing to talk about levels of sentience because we just don't know enough to talk about this species being more sentient than that or so forth. So in terms of, the minimum level, I guess I wouldn't want to talk in terms of levels. What I'd want to talk about instead is application of the precautionary principle, such that if there's sufficient evidence to suggest a possibility or probability, but we'd have to agree on a threshold for sentience, then we would protect those animals in any event.
Yeah, absolutely. And I tend to agree with you. I think that the conversation around level of sentience is very dangerous because of the lack of evidence and just how difficult it is even to get to this point where we've been able to have some scientific evidence behind sentience on those species that typically are very difficult to study and measure their behaviour and reactions and things like that. So it's a very interesting space. Once again, I'm going to apologise. We haven't got through all the questions, but it shows a great level of engagement. Thank you very much, Jane, for joining us. And you will be staying on for the panel this afternoon. So we look forward to furthering those discussions then. So thank you very much again, Jane.
Wonderful. Thanks so much.
Thank you.